Good morning. Thank you for having me here. I'm a little tired. I haven't slept in the last 48 hours because there's a Category 5 hurricane heading more for my home outside of Miami. So if I am a little spacey, just ignore it or yell out, "You're spacey," and then I'll try to do something about that. So at the Animal Rights 2017 conference in Washington, D.C., about a month ago, I gave a talk there in which I announced that the time for animal welfare, animal protection, which began in 1821, has peaked, and it's about to start a downward movement, which is good, because the idea of animal rights, and I'll talk about what animal rights are, is beginning to take hold, not just in the United States, but in other places throughout the world, and I'll mention those briefly. And it's only going to go in one direction. It's going to go up. And ultimately, we argue that you want to have legal rights for non-human animals for the same reason that you want legal rights for human beings. Because without them, your fundamental interests, or even your most fundamental interests, are simply not protected. All legal history shows that the only way in which the fundamental interests of human beings are protected is if they have legal rights that protect them. And we're trying to then apply that lesson of history and of politics and of law that we learn from human beings to non-human beings. Now, since Roman times, more than 2,000 years ago, there's been this wall, I call it a great legal wall, that separates legal things on this side from legal persons on that side. So here's our great legal wall. Now, a legal thing is an entity that lacks the capacity for any kind of a legal right. So a legal thing is invisible to civil law. They do not count. Judges cannot see them. What they are essentially are the slaves of legal persons. Legal persons are on this side of the wall. Legal persons are those entities who have the capacity for at least one legal right. And legal persons are the masters of the slaves. And that's true whether you're talking about the fact that I'm a legal person and this microphone is a legal thing. I'm clearly its master. But it's also been used, as we know, in other insidious ways. Human beings have been legal things when they were slaves and they were used by their masters. Every non-human animal in the world is a legal thing that is being used by its masters, which are us, because we're all on this side of the wall. In 2017, all of us in the room, and I don't see any non-human animals, maybe there are. If you're out there, you're not on this side of the wall. But if you are a human being, then you are on this side of the wall. You are a legal person. If you are on this side of the wall, you are a legal thing. And all human beings right now are legal persons. All non-human animals are legal things. However, it always hasn't been that way. And one of the first things that the Non-Human Rights Project has to do when we bring a lawsuit is to persuade, and really it ought to be, to remind the judges before whom we appear that being a legal person and being a human being have never been synonymous, are not synonymous today, and never will be synonymous. Most judges that we go in front of don't grasp that legal fact and the fact of legal history. So if you look back, say, to 1770, and the reason I say that is because things happened in 1771 and 1772 in England concerning the legal thinghood of slaves, which I'll talk about in a second. But if you look back to 1770, all of the non-human animals at that time were legal things, but there were millions of human beings who were also legal things. They were the slaves. And of course, all the plants of the world, all the inanimate objects of the world, all of them were legal things. So on the other hand, there were indeed human beings who were legal persons, but it was not all human beings. It was just some human beings, perhaps white human beings, perhaps male human beings, perhaps white male human beings. And at various times throughout history, children were things, or women were things, slaves were things. And a lot of the civil rights work over the last couple centuries or more has been to slowly move all of those entities, the human entities who were once legal things, through this wall. So it's kind of a semi-permeable wall, to move them through that wall and put them in the category of legal persons. But today, there are many legal persons who are not human beings. Because you have to remember, as we try to tell the judges, and some of them insist on not believing us, they aren't educated, unfortunately. We try to educate them. Right now, there are numerous legal persons on that person's, there are numerous non-humans on that person's side of the wall. The easiest example, perhaps, is that of a corporation. A corporation is a legal person who has many, many rights. And they differ from state to state or country to country. In the United States, they even have rights of free speech under our First Amendment. They have a right to corrupt our elections by giving huge amounts of money. So it's clear, and Americans understand now, over the last five or 10 years, that corporations indeed are legal persons, just the same way that I am, and they have many of the same kind of rights. But again, a legal person is an entity that has the capacity for a legal right, and it may include human beings. Now it includes all human beings. Once it didn't include all human beings, but it includes other entities as well. So I'm a common law lawyer. I practice in the United States, and a common law lawyer, or the common law is the law that English-speaking countries around the world use, whether it's Australia or India or South Africa, or the United States or England. And so if you look at some of our sister countries, common law countries, for example, New Zealand, or if you look, New Zealand actually is a terrific example, because in the last couple of years, what I'm saying to you has been made very clear by the New Zealand Parliament. Within the last year, the New Zealand Parliament has said that a certain river, the Wanganui River, is a legal person. And it truly is a legal person. It has the capacity for legal rights, and at least one of those rights is the right to own its own bed. They also held last summer that a national park in New Zealand was a legal person that has certain kinds of rights. In India, before the Indian independence, a mosque was held to be a legal person. A Hindu idol was. In the year 2000, the holy books of the Sikh religion was held by the Indian Supreme Court to be a legal person. And what a legal person is an entity who counts, that a jurisdiction says these entities count for whatever policy reasons those jurisdictions care about. Those entities count, and the way you count in law is only one, and that is you must be a legal person. So the Non-Human Rights Project is acutely aware of this. And of course, what I did leave out was the fact that in November of 2016, an Argentine court held that a certain chimpanzee named Cecilia in Mendoza was indeed a non-human person. And Cecilia had filed, or someone had filed on behalf of Cecilia, a writ of habeas corpus, and the judge then had ordered Cecilia released pursuant to the writ of habeas corpus from the zoo in which she was imprisoned and sent to a sanctuary in Brazil. So the Non-Human Rights Project, as I said, is aware of all of this, and our job is to try, as Fabienne says, is to begin to try to persuade courts and parliaments as well that the time has now come to begin to move at least some non-human animals from the thing side of the wall, again, through the wall, like so many humans have gone, to the person side of the wall. And so I began thinking about this in 1985, and that's when I realized what I'm telling you. So what I'm telling you over the last 10 minutes, it took me about 30 years to figure out. Well, it actually didn't take me that long. It took me about 8 years to really figure out. I went down several kind of theoretical blind alleys and until I realized at about 1985 that that was the problem. And I understood that since Roman times, all non-human animals had been legal things. So it wasn't going to be easy all of a sudden to change any non-human animal, to convert her from a legal thing to a legal person. But that was what was going to have to be done, because that was the only way that the fundamental interests of a non-human animal would ever be reliably protected. And so in 1985, I concluded that it would take about 30 years before the first lawsuits that had any kind of a reasonable chance of success could be filed. So I thought in 1985 that it would take till 2015, the 30 years of preparation before we'd even be able to file the first lawsuits. And it turned out that I was too pessimistic. It only took 28 years. So that was in 2013. But there was a lot to be done. So in 2013, the Non-Human Rights Project then sought a writ of habeas corpus, and I'll talk about that. Actually, we sought a common law writ of habeas corpus on behalf of a chimpanzee in the state of New York in 2013. So I just kind of want to briefly talk about, how that happened. And the preparation for it was enormous. At that time, in 1985, there were no law school classes on animal rights law. Now, I've been teaching one at the Vermont Law School for 27 years. And I teach in Barcelona at the Autonomous University Law School. And now I've taught animal rights law at Harvard Law School. I've taught animal rights jurisprudence at Stanford Law School, at the University of Miami, at St. Thomas, at John Marshall. And so, some of these are kind of pretty good law schools. And it's good, the fact that they're ready for that, I think, is indicative of the fact that at least elements of the legal profession and the academy are beginning to accept and at least think about seriously these sorts of ideas. And so we had to begin to get law school classes. We had to begin speaking to our brothers and sisters in the legal and the judicial professions through law review articles, through books. I wrote law review articles. I can't remember how many I wrote. I've written 21 of them now, but over the first 10 or 15 years, I probably wrote about 8 of them until I realized that this was not the way to educate anyone, because nobody reads law review articles, and even my mother was not reading mine. So about 1998, I found a wonderful editor of a trade book, trade books, and she helped me learn how to make a book proposal, and I ended up writing the book that was called Rattling the Cage Toward Legal Rights for Animals, which I think is I saw it on sale out there as I walked in. And so we had to be able to write books and law review articles. We had to be able to teach classes. We had to be able to get judges to have some kind of idea what we're talking about, and lawyers and law professors to have some kind of idea of what we were talking about. But of course, perhaps the most important thing was the fact that there was a gigantic world out there that ranged far beyond lawyers and law professors and judges. And those ultimately are the people that we needed to reach. And so we began to make radio appearances, TV appearances, try to get in newspapers and magazines, and do everything we could to begin to get the idea out. But of course, we were just a small part of that. There are probably thousands and thousands of animal welfare, animal protection organizations that constantly now remind people that non-human animals, count. That if they don't count, they certainly ought to count. And so we might have been ready to go 20 years before, 15 years before we filed our first lawsuits. But we didn't think that the world was ready to hear us. And it really wasn't until 2013 that we felt, we think now the world is ready to hear us. This is the earliest time in which we think that we have some reasonable chance of winning. And so we filed a common law writ of habeas corpus. And common law, it is that law that English-speaking judges make as a byproduct of deciding cases. Now, civil law folks and common law folks don't have any understanding of what the other people are doing. They're really dramatically different ways of viewing the law. And if you're a civil law folk, and especially if you're not from England, and if you're from almost any other part of Europe, or if you're not from the UK, if you're from any other part of Europe, what I'm about to say may seem strange, which is that in a common law country, common law judges actually make the law. The legislature makes the law, but so do judges, and that really doesn't happen much in civil law countries, where the legislatures, the parliaments, make the law and the judges interpret it. In a common law country, the legislature makes the law, but the judges do too. And only when there's a conflict between what the judges are saying and what the legislature is saying, does the will of the legislature trump what the judges are saying. Although the judges will then do whatever they can, if they really feel strongly, to kind of interpret what the legislature is doing in a way that allows what the judges want to keep going forward. So there's a tension and a fight between the judges and the parliaments. But the important thing is that the judges can make the law. And so the idea or the legal rule that all non-human animals were legal things did not come, at least in the English-speaking countries, from the legislatures. It came from the judges, and it came from them centuries ago. And so we did not want judges to be interpreting a statute that a legislature made or interpreting a constitution that somebody else wrote. And when they use the word person, we'd have to argue that when the legislature passed that statute or a constitutional convention enacted a constitution and they used the word person, we did not want to have to prove that they intended the word person to mean our non-human animal plaintiff. And so what we wanted to do was to go in front of the common law judges saying, you judge, or actually probably not you, but your ancestor judges from 10 years ago or 100 years ago or 800 years ago, that you were the body that made all non-human animals things, and therefore you can unmake it. And indeed, the common law is supposed to be flexible. And as experience changes, as public morality changes, as scientific evidence changes, the judges are supposed to change the common law to keep it up to date with those three things. And so we were then prepared to argue to the court that the idea that all non-human animals could be legal things was an anachronism. It was based upon experience and morality and scientific evidence that's hundreds of years old, that does not fit with the experience, the morality, and the scientific evidence of the 21st century. And so that's why we used the common law. Then we also used the writ of habeas corpus. Now, habeas corpus is Latin for you have the body. And at least in the common law tradition, and oftentimes I think in the civil law tradition as well, it's seen as being this extraordinarily important legal cause of action. Because what it means is that if someone is being held against her will, then somebody else can go into court before a judge and say, this woman is being held by that man, or this man by that woman, or this man by whatever. Someone is the holder and somebody is the holdee, or someone is the detainer and someone is the detainee. And the judge then issues the writ of habeas corpus. You have the body. In other words, the writ issues to the detainer who has the body, and the detainer, the person who has the body of the detainee, is ordered to bring the detainee into court and give a legally sufficient reason as to why he is detaining her. And judges care about it a lot. they will take immediate action. So one of the reasons we bring writs of habeas corpus is that unlike usual cases that can go on for months or even years, writs of habeas corpus happen, bam, like that. So if I go into a court and say someone is detaining someone else, the judge will issue the writ of habeas corpus, and that person may be ordered to come into court within 24 hours or 48 hours or 72 hours, really quick. And why do they do that? It's because the judges supremely value autonomy. Autonomy being the idea that an autonomous being can choose how to live his or her life. Judges in Parliament, certainly in the West, believe that autonomy is really the supreme value, that we live to be able to live our own lives, not the lives that others tell us how to live. Because we think that when you are that way and someone's telling you how to live, that's the same thing as being a slave, and nobody wants to be a slave. And so autonomy is this extraordinarily important quality. And so the detainer will be required to bring the detained person into court, bang, and give a legally sufficient reason. And if he can't, the judge on the spot will order the detainee to be freed. And judges certainly in the United States will be acutely sensitive to the fact that there might be somebody out there who's being detained. And if she is, then they want to know, and they're going to do something about it. So a writ of habeas corpus then happens really fast, and it's really good because it happens really fast, but also it's really good with financially and other ways for us, because what we want to do is get to the issue of whether a non-human animal can be a person. And we want to get to it fast, and we don't want to spend years getting to the point that we could get to in 24 hours, because it would tie up our money, it would tie up our man and woman power. We want to have the conflict, the argument as to whether or not our non-human animal plaintiff ought to be a legal person or is a legal person. We want it brought in front of the judge immediately. We don't want to wait a year or 2 years or 5 years or whatever. And so that's, again, one of the reasons we use a writ of habeas corpus. Another reason is that in many countries, certainly in the United States, there's something called standing. And that means that the only person who can bring a lawsuit is generally the person who was actually injured by the defendant. So if you're not injured by the defendant and you're trying to vindicate somebody else's rights, the judges won't let you do it. And so there is one exception, at least one major exception, and that's the writ of habeas corpus. And the reason being is that the person who's being injured is being held by the detainer. Usually, detainers don't let the detainee out to go into court to seek a writ of habeas corpus. In fact, it may never have happened. So what the judges understand that some third person is going to find out about that person being imprisoned, come into court and say, I think that person is being imprisoned, and ask that the judge be ordered, the judge issue the writ of habeas corpus, and the detainer be ordered to bring in the body so they can have a judicial hearing. And so that's what we do. We then, we don't have a standing problem in that we say, Judge, we know of a person, at least we argue that she's a person, who's being held by someone else, a chimpanzee or an orca or an elephant, is being held by somebody who claims that this chimpanzee is owned by him. Isn't that funny, Judge? And we want you to order that master to bring his slave in and give a legally sufficient reason for detaining him, for thinking that he owns him and that he can do whatever he wants with him. Because we say the chimpanzee up until now is not a thing, but is a person and has as much right to freedom as the human being who is holding him. So that's some of the many reasons why we really like the writ of habeas corpus. Then we filed on behalf of a chimpanzee. Now, why did we choose a chimpanzee? Well, we chose a chimpanzee because that followed something else that we do, which is we think it's strange enough, it's going to be strange enough to go in front of a court and say, we want you to treat a non-human animal as a person really for the first time in history. And so we don't come into court with our own ideas about it really. about why the judge should rule in our favor, about the principles and values that we're going to argue in front of the court, those are not ones that we make up or we think are right. What we do is we first look at a jurisdiction, and we spend a lot of time looking at the state of New York and all the other jurisdictions actually throughout the world, and we decide to use the state of New York, is that we want to know what are the values and principles that the judges say that they hold. And the way we know that is we read the decisions that the judges write, and they say, we really believe in liberty, or we really believe in equality, or we really believe in habeas corpus. And we note really carefully what the judges themselves say they believe in. And then we then go into court and say, we are going to assume that you're right, and we're saying if you believe in liberty, then we're going to make a liberty argument that says our chimpanzee ought to be person and be freed. If you believe in equality, we're going to make an equality argument. And if you believe in habeas corpus and think it's really important, well, so do we, and that's why we're bringing a writ of habeas corpus. And one of the things that caught our eye in the state of New York and other places as well is the idea that the judges keep saying that this idea of autonomy, of being able to choose how to live your life, is something that they believe in like fervently. They believe in it so much that if somebody, at least in the state of New York and many other states as well, and countries, I'm almost certain, that if somebody is in a hospital, and the hospital says, if you don't have surgery, you're going to die. Or if you don't take a medication, you're going to die. And the patient says, I'd rather die. I don't want to take the medication. I don't want to have the surgery. The courts will side with the patient. In other words, the courts will say that the patient's right to autonomy, to choose how to live her life, is even more important than the state's interest in her life. So we'd rather, if she wants to die, then we'll honor that choice. So autonomy is the supreme value. So the way we chose chimpanzees, certainly for the state of New York, is that we kind of went through the animal kingdom to say, which non-human animals can we go to scientists and have them write affidavits from the court that will make clear that our non-human animal plaintiff is autonomous? Because will be, we're hoping, the first crack in this wall, that we're going to send that non-human animal from this side, from the thing side, over to the person side. And so that's what we did. We then went to the world's greatest chimpanzee cognition experts, and I think we had 9 of them, from Jane Goodall on down, file affidavits that eventually totaled 160 pages, in which they made it really clear how chimpanzees were autonomous in great detail. And if you want to look at them, you can go to our website, www.nonhumanrights.org, and you can see what we file. In fact, every single case that we file, and everything that's filed in a case, everything a judge does, whether we like it or whether we don't, and a lot of times we don't, but everything goes up on our website. So you can see the arguments we're making, you can see the arguments that the other side are making, and those of you who saw the film, Unlocking the Cage, last night, about the work of the Non-Human Rights Project, were able to see, actually, me standing up in court and making my argument, and the Assistant Attorney General from the state of New York standing up and saying, I don't have any idea what I'm talking about, and me saying, no, you don't have any idea what you're talking about. And then having the judge, ask really, thought-provoking questions. Well, that was one judge. There was another judge in there who was really clear, simply wanted to jump over the bench and slap me. You get to see that too. So some judges are more open to these kinds of ideas, at least in 2017, than others are, and we expect that. So we then go into court, and we have in the state of New York, and argued that chimpanzees are autonomous beings, and we've proven it, Judge. We've proven that they are autonomous beings, and therefore, if you believe in autonomy, and if you believe in liberty, and if you believe in equality, just like you say you do, then you're going to have to rule in our favor. Actually, one of 3 things are probably going to happen. 1, you're going to have to rule in our favor. 2, you're going to have to say, well, we actually don't believe in those values. We don't really value autonomy. We don't value liberty. We don't value equality. As far as we're concerned, we don't really care what they say they value because we're positive that there's nothing that a judge can say she values that's going to include all human beings and exclude all non-human beings. So you just say, fine, just tell us what you value, and we're going to show you that our non-human animal has that quality. Because the judges have a really difficult problem, just like the philosophers have a really difficult problem. And we go over these in my classes. We try to, when someone argues that a non-human animal should not be a person, whether they're a judge or a lawyer or they're a philosopher or a theologian, they have a real serious obstacle. And the problem is that they have to make sure in the 21st century that all but only human beings are persons and nobody else is, which we think is in theory impossible. So the judges then, if they can enunciate any value they want, and we will be able to make the argument, and we know they're not going to be able to show that all humans have some kind of a characteristic and no non-human animals do. The third thing that they can do is they can say, yes, we do believe in autonomy and in liberty and equality, and then they can just arbitrarily rule against us. And if you go on our website, you will see some startling examples of judges really acting not very judge-like, simply not being able to meet our arguments and just kind of throwing up their hands and in one sentence saying, well, you lose because of X, without even bothering to explain why X is relevant at all. So, for example, we lost in one appellate court because the judge said, well, in order to have rights, you have to be able to assume correlative duties. And we said, well, number one, no court has ever said that. Number two, you just said it in one sentence, but you didn't bother explaining, why that was important. Number three, don't you have children? Haven't you ever noticed that when your children were young, they had rights, but they couldn't bear correlative duties or have responsibilities? And the first court just said, yeah, but humans collectively can have duties and responsibilities, whatever that means. And no other court has ever said that again, because it doesn't make any sense. But one of the good things about us losing on grounds that don't make any sense, there's nothing we can do about it in the short run because they're the judges and we're not. But when they issue irrational or biased opinions, those are inherently unstable. They're not going to last for a long time because judges and the law, at least in theory, are supposed to be rational. And when the judges begin to go off the rails and start issuing irrational declarations, not even giving reasons for what they're doing, but just simply saying something, then that is going to be unstable. And so we then lost a second time last March in front of a different appellate court who then noted our argument. Hey, what about children and people who are insane and people who are in comas? And they said, their argument was, you overlooked the fact that your client's not human. We said, no joke. So we said, and we have that on appeal. They said, you overlooked the fact that your client's not human. We said, yeah, the way that the lawyers in the 19th century who were arguing that blacks should not be slaves, they kind of overlooked the fact that they weren't white. Or the way that the lawyers for women who wanted to practice law in the United States in 1870 kind of overlooked the fact that they weren't males. Or the way there was a Native American case where an Indian chief was being imprisoned, and they used a writ of habeas corpus to try to free him, and the U.S. government argued that a Native American was not a person, and the judge held that they were. So it's kind of like the way that they overlooked the fact that he wasn't white, he was a Native American. And then one of my favorite cases, if you call them favorite, is a case called People versus Hall in front of the California Supreme Court, actually in 1854, where there was a statute that said that a Chinese person could not testify either for or against a white person. And that was the issue in front of the court. The statute said that black people couldn't do it, and neither could Indians. And the question in front of the court was, when they said that, did they mean to include Chinese people? Or did saying blacks and Indians, was that kind of generically people who weren't white? And so the court held it means generically. That means the Chinese person who saw a white person murder another Chinese person could then not say he did it, and the person was acquitted. And so in that way, when the Attorney General of California argued that shouldn't be, well, I guess the Attorney General of California kind of overlooked the fact that the Chinese person wasn't white. So what we're telling the courts now is that we have been there before, where these kinds of irrational, and probably, they may not actually be irrational, because what they are is rational only if you are biased, if you have a serious bias against Chinese or Native Americans or black people or women, and that, Your Honors, explains what you're doing. Because you have a bias against the very idea that a non-human animal could be a legal person. And this was especially ironic in the last case, because the judges actually went through a large number of qualities that we had shown that chimpanzees had, and they were left with simply saying, and this was in half of one sentence, well, you overlooked the fact that your client isn't a human. Well, yeah, we did overlook that fact, because it's an irrelevant fact. And you have to understand that every single fact is not a relevant fact. We can say brown-eyed people shouldn't have rights, or we could say people with blonde hair should have rights, or people who have, whatever, long fingernails should have rights, or gray hair should not have rights, whatever. All you're doing is picking out a fact, but you're not explaining to any degree why that fact is relevant. Does that say 0? Ah. Yeah. I was finished, really. So the reason that I wanted to stop now is that I wanted to give people a chance to have a Q&A for at least 5 minutes, correct?
Yeah.
So I'm ready.
Thank you. Oh. Do you have a question? No.
I would like to say that I'm not alone in the Non-Human Rights Project. There's some terrific lawyers, terrific lobbyists, all kinds of terrific people there, and so I'm going to take that applause for them too.
We have one question here. Hi, my name is Mandela. I'm from Chile and I live in Luxembourg. So my first question is, when you mentioned that you started this back in 1985, I was born in 1985. That made me think a lot about how things were then and how they're now. Excellent presentation, but you didn't explain what got you into animal rights. I think a lot of people are wondering that. Thank you.
Well, do you mean animal welfare or animal rights? Animal welfare was when I read Peter Singer's book, which I recommend to everyone. In 1980, I read that when I had really long, luscious brown hair. In fact, if you look at Rattling the Cage, I think I still have kind of long, luscious brown hair in 2000. I don't know what happened. So that's, now what got me involved in rights, I did mention, which was after trying to figure out how we're going to deal with this huge problem that affects us, I realized that it was a matter of personhood, and that the only long-term way of dealing with it was to get personhood for non-human animals. Now, some people think that I'm putting down animal welfare, animal protection, which I'm not, because this struggle, this fight that the Non-Human Rights Project and others are involved in is really a fierce, long-term battle. And while that's happening, and it's happening, there are billions of non-human animals who are being tormented and killed and tortured, and animal protection folks and animal welfare folks, they have the duty and they do a fantastic job of going in and doing the best they can to get some small part of justice for legal things. They're doing the very best they can, and they are indeed helping, many large numbers of non-human animals. But the only way you're ever going to really protect them is through rights.
Unfortunately, we are running out of time.
Well, that's it. One
Would you
question.
be available if people approach you outside?
I invite you to
Would that be
approach
okay?
me outside.
Thank you very much. Thank you.